Hello, everybody. Hello, Nana Laura. Hello, C-Rex. Hello, Eileen E. Carlin. Hello, Jenny Green. Thank you so much. The Honorable Ava is quite amused. Hello, Linda Applegate, my sweet sweetheart. Hello, Spider-Man. Oh my gosh, hurry back. Ooh, hello, Mortimer Duke. I have a special surprise for you. Very, very special. Okay, so I've been talking a lot lately about those graphics that I was having made. Hello, K. John Boom. Okay, so, I guess first things first, because otherwise I'm not going to get to tell you about the graphics. I'm pretty happy with them. I think I might need to reach out to my usual graphic designer and ask her for maybe a little tweaking. Maybe just a little bit. But for the most part, I think they're fantastic. I just want them just slightly more to the brand. But it's really hard for me to explain things like that. So, I think they're great. I think they are. All right, guys. Last one. And shh. Okay, so this is Bandit. And this is Tiny Kitten Esquire. And if y'all remember the case with the trust, the $1.7 million trust. Now, you guys know that I get all of my inspiration from you guys. So Mortimer Duke made a comment. He said, "In Ricky we trust." Of course, that inspired me to have this next graphic made. And after it was done, then I had to do a little tweaking of it on my own with my very minimalistic design skills that I do have. But I did it, and I think it turned out perfect. Here we go. In Ricky we trust. I had him made into a $13 bill for the 13th Judicial District of Kansas. It's series 2004 because that is when the Honorable David A. Rickey took the bench. If you notice the serial number, it begins with D01 because all of the Kansas cases from that area, they begin with either D01 or D03. So, and it's the PAWFURM reserve note. I love it. I love it so much. Well, he's here. I told him to be here. I told him he had to be. Unless he's already fallen asleep. It's a possibility. But yeah. Oh, you mean to send it to Judge Rickey? Oh my. I don't know. I don't know about that. Oh, and it has the seal of Kansas. Just to the left of Judge Rickey's face, it has the seal of Kansas. And then under the 13th, of course, is the Night Shift with April logo. So I'm so excited. I think it turned out beautiful. I love it. I'm amazed. I feel so blessed to have that as the newest graphic in the PAWFURM merch line. So, and if anybody wants a shirt or a hoodie or anything made with it, I have the ability of doing all merch. I don't have a store, because I don't have the ability to manage a store, all entirely by myself. So, if anybody wants something custom made, I have the ability to do that. So, yeah, there's that. Well, if I had that, it might be, but I didn't exactly have that. Oh my gosh. Thank you all for being here and for being a part of that glorious moment. I don't know if you can tell, but I'm super stoked about it. Yeah, I think the PAWFURM reserve note kind of took it out of the realm of even being considered as being attempted to be used as currency. It no longer says the Federal Reserve or anything like that on it. I was very specific about this. The entire concept and every ounce of detail in it was my concept. I just don't have the graphic design skills and abilities to make it happen. And I don't know how to use that AI stuff. That's why all of my cases and stuff are still edited by me. Well, if so. Oh, look at Earl. He looks like he's going to jump into that drawer. All that's in there is a blanket for them. I made that into a kitty bed so that they could snuggle up inside of there. Billy's the only one that's used it so far. The actual treasurer, it's the same as what's on the $1 bill. I can do mugs. I can even do pet jackets, like the dog hoodies or bandanas. I can do glasses, shirts, hoodies, underwear, you name it. Anybody want Judge Ricky on their drawers? There we go. There we go. All right. And so tonight we've got a variety, a whole bunch of stuff. Lots of fun from all over the place. My arm's getting tired. Thank you, Missy. She had to go to the vet today. Hey, I'm taking it back. So yesterday was Tiny Kitten Esquire's appointment. Today was Ava's appointment. Tiny Kitten gets spayed in 2 weeks. Ava gets spayed in 8 days. So, oh no, hold on. Oh, I'm going to get in so much trouble for this. Oh, thank goodness this is the night shift. Oh, I can't believe I'm doing this. This is the one for the jock straps. Oh, okay, take it down. The PAWFURM logo that's up in the corner, that's not actually on the picture. That's just, that's just on the stream, so it automatically shows up on there. But I know it was kind of blocking the text at the end there. I couldn't resist. I put it in the naughty nightstand. See? By the way, I made a Swiss cake roll today. Yep. I left it on the doorstep of a friend of mine. And as far as the filling for it, I just did a vanilla. I know, I'm so plain. But I didn't know what kind of fruit they would want. So I just did my own special vanilla blend, and it turned out amazing. It really did. I've got extra vanilla stuffing for it. The one thing I did not get to turn out was that ganache frosting that you gave me the recipe for, with the whipped cream and the chocolate chips. I don't know what I did wrong, but it was just ooze. So I just oozed it over the top of the Swiss cake roll. I figured good enough, right? What was, honey? What was? You were putting that up there? Oh no, it was all me. I can't even blame that on them. Oh, I'm so happy. You guys make this the greatest life. You really do. I'm going to put on the dockets for tonight, and we're going to have so much more fun. What did I name it? Oh, I hate when I get to this part. It's not in there. It was, oh, I know where it went. Golly, I really got to consolidate stuff. Get some kind of a system, like the professional I am. Oh yeah, here it's going to be. And there it is.
We can call the matter of Tyler Lagerway.
All right, we have Mr. Tyler Lagerway, cause number 280292727. Morning, sir.
Good morning.
This is on for a probation violation. I'm just going to see what it is. Okay. So, Mr. Hooper, it looks like we have a new one actually dated today. It has 2 violations alleged.
That's correct.
All right. So, at this point, Ms. Levine, are you able to admit or deny the 2 violations?
We will be admitting to violation number 1 and then admitting to violation number 2 as to charge only.
Okay. So, Mr. Lagerway, number 1 is just admitted. That was failure to report to probation after a release from prison in January. Number 2, admission only that the charge was filed, not as to the guilt of the charge. With those admissions, Mr. Hooper, what's probation's request here today?
Probation's recommendation is for revocation of probation and 180 days.
Okay, let me take a look at.
We have set appointments as the recommendation. Mr. Lagerway has indicated that in between being released from prison, he was there for about 10 to 11 months, and then connecting with his DOC supervisor, county probation just sort of slipped his mind. He is willing to set appointments, fully comply, do any sort of treatment or evaluations that are necessary, and would be willing to set appointments as soon as today, go in today. And
so I guess there's a couple of different ways we can move forward with this. Given the fact it sounds like there was a little bit of a miscommunication here, I would be fine withdrawing the admissions and just entering them as denials if you need some additional time to talk with Mr. Lagerway. I guess the other question I would have, Mr. Hooper, is there any version of reality where probation is still willing to work with Mr. Lagerway?
Well, it looks like he's picked up new charges. He's still being monitored by DOC. There's a possibility he might be going back into custody on DOC. So his probation officer indicated that she felt that this should be over.
Okay. So let's do this, if you're fine with it, Ms. Levine. Well, let me clarify. Are you prepared? It sounds like that is probation's recommendation from what Mr. Hooper has said. The probation really isn't willing to keep working with Mr. Lagerway. So do you want to proceed today with potentially a revocation, or do you want some additional time to speak with Mr. Lagerway and maybe we can change this to a couple of denials and set it over in the next week?
Let's take a couple of moments just so that we can chat, if possible.
Do you want to just put it today, is what you're saying, and then recall the case?
Yes.
We just have like 2 seconds.
If, just 1 second.
Okay. All right. Just make sure you're muted so I can't hear you guys. You are still muted over there. I just so you know, counsel. I don't know if that's still intentional or not.
Thank you, Your Honor. So in Mr. Lagerway's case, I understand that he's admitted the violations. What we're going to be recommending as for a sentence, as for a sanction on probation is he would like to not revoke his probation at this point. He'd like to be able to have the opportunity to set appointments with probation and comply with it. Mr. Lagerway also is planning on going to inpatient treatment to get some structure in his life. And this is a situation where it looks like he was in DOC for the last 10 or 11 months, and when he was released, he went and checked in with his DOC officer, but appeared that he didn't realize that he had to meet with county district court probation as well. I think given that situation especially, and it's generally our intent, if not, it's generally our intent to not double people up on probation like that when they have DOC. Just ask for Mr. Lagerway to have a second chance here before we take the extreme measure of revoking somebody on probation when they're already being monitored by DOC.
All right. Thank you, Mr. Smith. And Mr. Smith, I realized you were in the attorney room, but I did ask Mr. Hooper if probation was willing to continue working with Mr. Lagerway, and probation essentially indicated that they didn't believe it was appropriate at this time, and they're asking for revocation either way. Just so you're aware that that's where we're at.
I understand that, Your Honor, and thank you. I certainly appreciate that, and I certainly understand probation's position here. I think that it's a little different for Mr. Lagerway's situation, where it's not like he was on warrant status, just in the community doing whatever for the last 10 or 11 months. I mean, he was in the custody of the state, and when somebody's in the custody of the state and is unable to comply with their county district court probation conditions because they're in the custody of the state, I think that merits at least some leeway. Thank you.
Okay. Well, Mr. Lagerway, I reviewed your criminal history. I don't think there's any way for me to say it other than this is one of the worst DV histories I've ever seen. I counted 21 prior domestic violence convictions. So you are on very thin ice at this point. I think the only way I'd even consider allowing Mr. Lagerway to remain on probation, I think minimum probably a 20 or 30-day sanction at this point, and then see if he can actually follow through with what he needs to do. So I understand probation's position, Mr. Hooper. If I were to order, perhaps I would say, honestly, I think about a 30-day sanction and then give him one opportunity. Would you have any strenuous objection to that?
No, we'd be okay with that.
Okay, Mr. Lagerway, usually this kind of sanction is probably around the 5-day mark. I'm going to be completely blunt. Your history is so bad. I think that 30 days is more than warranted here, and I'm going to order that, but I will give you an opportunity to stay on probation. So instead of sitting out 180 right now, sit out the 30 days, report to probation, and then at that point, do what you need to do. Hopefully that's the only time you're going to have to serve on this.
Still not enough. I'm sorry. I think they should have revoked him. I think he should have gotten the full 180. Probation doesn't want him anymore. He clearly doesn't follow their directions. Why give him this opportunity? What has he done to deserve it?
All right.
Okay? So give me just a minute to fill out the order, and then I'll be right back with you. Mr. Hooper, do you want to set a review at this time, or just review as necessary?
Let's review if necessary.
Okay. Okay. Order reads basically exactly what I already said, Mr. Lagerway. We have violations 1 and 2 admitted. Number 2 is this to charge only. Continue on probation. It really is your only chance here, I think, given your history. Probation's request to revoke today is denied. I'll go ahead and allow you to continue on as requested by defense counsel. However, I am ordering the 30-day jail sanction. You'll be PR'd on this once the commit's served, and then you need to report to probation immediately upon release from custody. We'll review as necessary. I'm not going to set another date at this point, so the ball is really in your court. You just got to do what you got to do, and if you don't, I think 180 days is probably the minimum the court would consider on a revocation, given the history that you have. So just beware that that's where we're at this point. Do you have any questions for me, sir?
No.
Okay. It's ready for signature, Mr. Smith.
Thank you, Your Honor. And Mr. Lagerway, I'll just mark it in court for your signature, if that's okay. All right, we have signed off.
Thank you. All right, sir. Thank you very much for your time and your patience with me. Good luck. Just make sure to check in with probation once you're released.
Let's see. Mr. Carl, I got you up in the corner. It looks like. What?
Yes, Your Honor.
Who's your client here?
My client is Lisa Kibbe.
Kibbe? Okay.
She's on the phone with me.
Okay, let's see if we can make that work. Let's see,
She
Kibbe.
tried to get on Zoom, but she couldn't, Judge. And this is the information I have for you, Judge, is that she tried to go to an alcohol evaluation, but they all wanted at least $250. So she has got herself set up to go to Meridian.
Well, let me just kind of cut you out though. It's just she didn't show up for her assessment. With Mr.
Okay.
Gerhart.
Where was she supposed to show up?
Downtown. Well, she was supposed to call Mr. Gerhart.
Mr. Gerhart, the probation officer.
Right. It looks like she didn't do that. It says defendant was scheduled for a drug and alcohol screening appointment on March 12th, failed to appear.
She thought she had to do it on her own, Your Honor.
Sir, I'm sorry, Mr. Grant, I tell them every time that they're gonna get a number of the phone, they just need to call the phone number. So she's
Well-
gotta be a little bit more responsible than that. In fact, this is the second time it happened.
Second time she
Yep.
didn't get an
November-
assessment?
Yep. November 27th, 2024, I ordered an assessment, set it for January 22nd. Then I had to reset it again for today. I'll set it one last time, Mr. Carl, and you can tell her this is it. Otherwise, we're just gonna proceed and it's not gonna be good.
She's going into rehab on Friday at Meridian.
Well, she better get in and see Mr. Gerhart then. She better call him.
Okay, listen, the judge is saying you need to call Mr. Gerhart immediately.
Yeah,
All right, Judge, do you happen to have his number right there? So I
Yep,
can tell her right now.
sure. 810.
So, I'm gonna give that to her as soon as she gets a pen, Judge.
Okay. And then we'll set
Okay, can you take,
a new date for her then, see where she's at with her.
wait, hold on, stop. I'm sorry, Judge, I didn't mean that to you. Okay.
Yeah.
Sorry, I apologize.
It's all right.
Okay, does she have to go there or does she
gotta
have to call?
She's gotta call him.
Okay, all right. Okay, all right. So the number, I'll give that to her, Judge, unless you want me to do it on the record.
No, that's okay. Just give it.
Okay.
She's had it a few times now.
Okay.
She ought to have it.
What's the next date, Judge?
Let's see, April 30th
Okay. At,
at 8:30.
okay,
It'll be on Zoom again for her. So even if she's at the rehab center, she can get on Zoom and we'll do it that way.
well, she hasn't seemed to have been able to get on Zoom.
Okay, well, she's got to figure it out over there. They'll help her.
Okay, are you at Central or not?
Well, I'm at Central right now. Me?
Oh.
talking to me?
I could have came down there. Okay.
Listen, yeah.
I already didn't know that. Okay. So will you be at Central that day?
I don't know, but I do these on Zoom. So one way or the other, either, you should be on Zoom.
All right. Okay. Thank you, Judge.
All right, you're
I
welcome.
appreciate it.
You're welcome.
And that's at 8:30. Okay.
8:30. Yep.
Bye.
All right.
Bye.
And Mr. Childers.
I guess we could do Dean.
Dean, I think it's Dean somewhere.
She's up for sentencing, but didn't get her pre done.
Oh,
She
here it is.
said
Caitlin.
she first time she'd been in trouble, she said she was nervous or she didn't hear. I don't know, but she didn't get the screening done. So
Okay, Caitlin, Dean.
Yes.
Actually, I issued a bench warrant me first for failing to appear too.
oh,
You're not doing two things. You're not showing up for me and you're not getting your assessment. The assessment,
Yeah, I'm not.
a little bit more lenient with you, but you got to show up for me.
I absolutely will. I'm very sorry.
Why didn't
I'm
you?
not sure what. I was in between moving when I got into the trouble. I didn't. I'm assuming I didn't get the piece of mail for screening. I'm not sure what
Okay.
that even is, but I'll figure it out.
Okay, so I'm going to give you a phone number to call too for your assessment, okay? This is
Okay.
from last year, it's getting old. 810.
810. And thank you.
Call them right when we hang up, okay? That'll put your mind at ease too. Just get the assessment and we'll set a new sentence date for, what we got? April 30th.
It always amazes me when these defendants are like, oh, I forgot about it, or I didn't know who to call, so I just didn't do it. You have requirements on probation. Like, it's not a shock to you. And you have to know there's going to be consequences. Why would you not call the courts or call your probation officer and just say, hey, I know the judge said something about a screening, but I don't really remember exactly what it was. Can you explain it to me a little bit more? Or I'm having trouble booking it, or I can't afford it. Can you help me out with that? And by golly, they will.
At 8:30, okay?
Okay.
And we'll send you a new notice, but just get that done for me, all right?
Absolutely.
Okay, all right, and you're all set.
Thank you, sir.
All right, you're welcome.
we could do Lacey, Your Honor.
Lacey, okay, Chase Lacey. Chase Lacey was set for.
sir.
Yes, that's a sentencing, Your Honor.
Okay, did I get an assessment?
Doesn't look like it. He said no, and my looking at the file I couldn't see, but I didn't look. I had a lot of files, so.
Doesn't look like it, and it was a reason for it. It's a pled to, possession of drug implements in a second file.
I asked him if the court had asked him to do anything. He said just not use and stay out of trouble is what he said, but I don't know.
Well, that's a big part of it.
Yes,
so we'll
yes.
get through that. Sir, are you in any counseling right now?
Just outpatient rehab through New Paths.
Okay. Well, are you still counseling there?
Yes, sir.
You know
He
what,
said
Mr.
I'm sorry, Your Honor. He said he's working last 6 months in construction. He did 4 days in jail. He said he completed the inpatient program in New Pass, but that was a couple of years ago. But he's still he's back in outpatient, so sounds like he's doing better, Your Honor.
Okay, and looks like on this particular case, smoking illegal drugs. I'm not sure what it was. Just be right up front with me. What were you, on the date this happened, it says smoking illegal narcotics. What was
They
it?
had found a pipe and a pair of pants. So I had relapsed. My girlfriend was diagnosed with stage 5 kidney failure, and my brother had passed at the same time. I relapsed, got really drunk, and a domestic had happened that's been dismissed now. And I went to jail. It's gonna sound crazy, but it's the truth. I went to jail in somebody else's pants, her stepdad's pants, and they had a pipe in the pocket. And they asked me in the car, do you have anything? I said, no, sir. And then when I got down to the jail, they found a pipe and a piece of rubber in my pocket. And they're like, oh, you lied to us, and
Okay.
that was it.
Not my pants. And honestly, this is actually probably the only not my pants story I think I've ever even kind of believed.
I've got to ask, how'd you get his pants on?
So I was in the process of moving out at the time, and we were in a huge argument, and I was pretty inebriated.
Okay, so you just grabbed whatever you could and
Yeah, the cops were there. They were being pretty impatient with me trying to grab my stuff as I was drunk, and
okay.
I just grabbed my stuff.
Your Honor, client's minimized, but he's admitting how drunk he was in relapse. So
Yeah. Okay. All right. So I'll tell you what, and you're telling me the truth that you're still counseling in some degree?
Yes, sir.
Do you work full time?
Yes, sir.
Okay. All right. Let's do this then. We'll forego the assessment. I'll order 4 days jail credit for 4 days. And I'm trusting that's the case. Okay.
Yes, sir.
Boy, I'd rather have you in treatment. You're going to do that, right?
Yes, sir.
Okay. Did you give the pants back at least? No.
There was a no contact order, so he didn't get.
Well, now that that's lifted, go give him his pants back, okay? He might be missing them.
All right. Thank you, sir.
All right.
keep up the treatment, Mr. Lacey.
Yes, sir. Thank you.
All
You're
right.
welcome.
Good luck to you, sir.
Yes, sir.
Some things I'm pretty sure are pretty accurate.
Yeah, I'm used to clients minimizing, but as he's minimizing that, he's admitting how drunk he was in relapse. So it sounds believable almost. So
Yeah.
we could do Walker or Young, Your Honor, either one of them.
Okay. Walker or Young? Let's see, I've got right on top, Brandon Walker.
Yes, sir.
Mr. Walker and Mr. Childers.
Your Honor, he's got 3 files. He's going to plead to disorderly person. They're going to dismiss resisting, obstructing, and refusing to ID self. And he did 7 days in jail.
Okay, the only problem is I got to find the other file.
Yeah, it's written. There should be 3.
Oh, on the same complaint? Is that what it is?
Maybe, I don't know.
Yeah.
There's 3 on my docket.
Okay, let's just see here. Refusing attendance. I've got, we want the, I'm sorry, disorderly, right? Is that what it was?
Yes.
I'm looking for. I've got refusing ID in front of me. The other was resisting, obstructing.
Yeah.
Let's be the
They
other.
should end in 9-6, 9-7, and 9-8. The disorderly person looks like it's a separate case.
Resisting, obstructing, if that's what that is, I don't know, looks like.
Yeah, that's
Refusing identity is going to be dismissed, and then just disorderly, right?
correct. That should be I got a case number 23A01297.
Okay, hold on. They just Robin just gave me the other couple, it looks like. Yep, I've got the disorderly on 1297.
Okay. I think it's written up that he was pleading to the R&O, which what's written up, but I talked to Attorney Stripmatter and he agreed to change it. So he's pleading to disorderly and the other 2 are dismissed.
Okay, so let's make it dismiss per plea. Okay, Mr. Walker, I do have file 1297 in front of me. You're being charged with disorderly person on that file. Does carry a penalty of up to 90 days in jail and a fine of up to $500. It's alleged to have occurred in Flint Township, July 9th, 2023. Do you understand that charge?
Yes, Your Honor.
And you signed an advice of rights for me as well. Did you read and understand those rights?
Yes, Your Honor.
Okay, how do you wish to plead?
Guilty.
Okay, is it true that on the said date, time, and location, you're guilty of acting in a disorderly fashion enough to have the police make contact with you? Is that true?
Yes, Your Honor.
They'll do identify and then some other charges. Okay.
Sounds like they tried to talk to him. Mr. Walker, they tried to talk to you and you didn't want to give a name and then you didn't really want to cooperate and that's what happened, right?
No, I was just being smart about it. Like,
Right. That's what I mean. You were just being smart about it and it kind of got out of hand, right?
Yeah.
All right.
Okay. Do you understand if I accept your guilty plea, you won't have a trial of any kind, give up all the rights that you would have a trial, and you may be faced with those penalties?
Yes, Your Honor.
Has anybody made any threats or promises to cause you to plead guilty?
No, Your Honor.
No? I'll accept guilty plea to disorderly person, dismiss the other two files, 96 and 98. And I'm sorry, Mr. Childs, I keep.
You're right. He did 7 days, and I think that's what happened. I don't think he fought with him. He just wouldn't listen, and I think they got frustrated and wrote him for some tickets. He was frustrated. He spent 7 days, so I'd ask the court to consider time served.
Okay. So we'll order 7 days jail credit for 7 days and just close this file for you, okay?
All right, thank you.
All right, gotta act smarter than that, though.
Yes, sir.
The other kind of smart, right?
Yeah, the other kind is, yeah, right.
You guys have a nice day.
You too. Bye now. They got, gosh, Mr. Childers, we keep getting a couple stragglers. I got iPhones. I don't know if they're.
You can take Miss Bendel, and then if you want to ID him or whatever you want to send him back, that's fine.
Sure.
Okay, guys, I just had to throw this one in. It's not even a case, but you'll see what I mean.
I can do it right now, I guess.
Okay.
I've got one iPhone. Sir, what's your name on that iPhone?
Perry. I'm here for my son, Alan Perry.
Oh, so you're here for your son? Okay. I'll leave you on there for just a minute. And then ma'am on the other iPhone there, what's your name? Yep, got to unmute for me there.
Jaquasia Pollard.
What, I'm sorry, what is it?
Jaquasia Pollard.
Collard, can you spell the last name?
Polllard.
G-O-L-L.
No, P. P is in Paul.
Oh, I'm sorry, Pollard, P-O-L-L-A-R-D. Okay.
Yes.
I don't have anything.
She's on my docket. I think Mr. Perry's a probable cause on a felony.
Okay. Oh, thanks, Mr. Jones.
Yep. I don't see Pollard on either.
She's his mother.
Hold on, sir. Just a minute. Let me just deal with Miss Pollard. You're not on our docket. Bam, I'm gonna give you a phone number to call. You're not showing up on our docket, okay? You got something to write on?
She's his mother.
No, it sounds like she's Mr. Perry's.
Oh, I'm
Perry's mother.
sorry.
Yeah.
I kept trying to deal with.
Yeah.
Okay, so both of you here for Mr. Perry.
Yeah.
Oh, and we don't have anything yet, though, right? So, okay, we'll leave them both on. Yep, we haven't dealt with Mr. Perry's files yet. Just stay right there, and when we do, I'll put you on the main monitor, okay?
All right, thank you.
We'll leave you there. Yeah, in fact, I'll just change both your names, and I think that's, how about Akeisha Spencer? I got
Oh,
one.
that's my mom. That's my
That's for you too?
Perry's got a whole list. Judge, all right, I'm gonna sign up so I can use this computer to do jail because Attorney Berlanga's got it. We got just as many in jail as we had here. So if anything comes up, just have Janet text me and I'll jump back on.
All right, thanks. Thanks, Jeff.
Thanks, Judge.
Yep. Let's see, I'm gonna get everybody's name. I'm just gonna put for Perry so I can keep track of everybody, okay?
Okay.
And Spencer's the same way. Okay, so I'll leave all three of you on the monitor and I'll switch it over to the main room in just a few minutes, okay? So you can hear, okay?
All
Okay.
right, thank you.
All right, you're welcome.
Go shut the door. I'm on court.
I already just talked to him. That's what the people even say. They like,
Ugly.
no,
Looking ugly.
I'm saying the automatic thing. So I pay is gonna keep calling.
My mama on here?
Yeah.
Mom.
I don't see her, but they said her name.
Right. I don't see her or hear her.
I'm about to go to the auction. I'll just hear about. I'll just try to listen.
You going to see him today?
Yeah. What time, you going or you ain't going?
Yeah, I'm going. Probably like 4:30.
Hey.
Huh?
You saying 4:30?
Huh? What you say? I can't hear you. You got it on mute? Can you hear me? I can't hear you.
Let's see. Okay, I should have the individuals for Mr. Perry. I've got 1, 2, 1 of you left. Oh no, there's the other one coming in back in. We'll put back in. Let's get that back. Looks like I got all 3 of you back in here. This matter is being scheduled for a probable cause conference for April 16th and a bond motion on that date by the attorneys, okay? So you're more welcome to come back on that day. The PCC, quite frankly, gets handled kind of outside of the court a little bit, but the bond motions will be in court. So if you want to log back in on that date, you know, I'll have you back in. Just when you come in, just kind of remind me that you're here for Perry, okay?
Okay.
All right. All right. So other than that, we're all set for today. We just rescheduled it.
Okay.
All right. Thanks for waiting. All right. Bye now.
Bye-bye.
Bye.
Sir, in the Nisqually Jail, good morning. You are John Leroy Landers.
Yes, Your Honor.
Good morning, Mr. Landers. You are before the court under 2 different cases, 25L000545. Actually, that's the only case you're in front before the court on. And that is a first pretrial conference. Ms. Arnold, how would you like to proceed with Mr. Landers' pretrial conference at this time?
Yes, Your Honor, the parties have come to an agreed upon resolution, and that is entering a guilty plea on criminal trespass and resisting arrest in exchange for dismissing the theft in the 3rd degree. That has been uploaded for your review. It includes 12 months of jurisdiction and a couple conditions and getting credit for the days that he's served in custody. And I have gone over all of his important constitutional rights that he is waiving by entering a guilty plea today.
Thank you very much. Mr. Landers, can you hear me okay?
Yes, Your Honor.
All right. Sir, I have in front of me a document entitled Statement of Defendant on Plea of Guilty. Did you read this document or did Ms. Arnold read it to you?
I believe she read it to me.
Okay. Did she answer all of your questions?
She did. Amazingly.
You are 31 years of age and you've completed a GED. Is that correct?
Yes, Your Honor.
This document indicates to me that in this case, you're asking to change your pleas to pleas of guilty to the crimes of criminal trespass in the 1st degree and resisting arrest. In exchange for that, the city has indicated that they will file or bring a motion to dismiss the remaining count, the charge of theft in the 3rd degree. Is that how you understand you are proceeding this morning?
Yeah.
Have you spoken with Ms. Arnold about the elements of the 2 crimes that you're pleading guilty to, criminal trespass in the 1st degree and resisting arrest?
Yes, Your Honor.
You understand what the city would have to prove if those 2 charges proceeded to trial?
Yes, Your Honor.
You understand that you're giving up a number of constitutional rights by entering a guilty plea. Have you discussed those rights with Ms. Arnold?
Yes, Your Honor.
And you're willing to waive those rights?
Yes, Your Honor.
It appears the prosecutor is going to be recommending 364 days in jail, 354 days suspended in each of these 2 counts, $5,000 fine suspended, a suspension of suspended sentence for 12 months on condition that you receive credit for time served, commit no new crimes, and have no contact with or go upon the property of the Target store. Is that your understanding of what the city is going to be recommending?
Yes, Your Honor.
And you understand that's just a recommendation. The court is not bound by that recommendation.
Yes, Your Honor.
You understand that if you're not a citizen of the United States, these guilty pleas could have negative immigration consequences.
Yes, Your Honor.
Paragraph 11 asks you to state in your own words what it is that you did that makes you guilty of these two crimes. That statement reads, on March 10th, 2025 in Lakewood, Washington, I did knowingly enter or remain unlawfully at Target. On the same date, I did intentionally prevent or attempt to prevent a peace officer from lawfully arresting me. Is that a true statement of what you did that makes you guilty of these two crimes?
Yes, Your Honor.
Mr. Landers, has anyone threatened you or made any promises to you to get you to enter this plea?
No, Your Honor.
You're doing this of your own free will?
Yeah.
All right. Mr. Landers, to the crimes of criminal trespass in the first degree and resisting arrest, how do you plead at this time? Guilty or not guilty?
Guilty.
Court is going to accept Mr. Landers' pleas of guilty. The court will make a finding based upon the record that Ms. Arnold has made, as well as the court's conversation with Mr. Landers, that he's entered this plea knowingly, intelligently, and voluntarily. It appears that he understands the charges he is pleading guilty to, the consequences of those pleas. And based upon his statement, there is a factual basis for both of these pleas. Court will grant the city's motion at this time to dismiss count 2 of the criminal complaint. The charge of theft in the third degree will be dismissed with prejudice at this time. Mr. Graham, anything to add to the city's recommendation regarding sentencing?
Your Honor, I believe Mr. Landers has approximately 9 days credit at this time. But that's the only thing I'd add.
Ms. Arnold?
Your Honor, it looks like he was booked on March 10th, and so I calculate 10 days of credit, but yes.
Thank you. Mr. Landers, is there anything you'd like to tell the court before the court imposes a sentence?
I apologize for my actions. I apologize for having to waste your time. Sorry for your inconveniencing everyone here, and hopefully this will not happen again.
That sounds good to me. I would really like not having to see you in jail. That would be great.
Okay.
So I'm going to go ahead and follow the agreed recommendation. On both counts, I'm going to impose 364 days in jail. I'm going to suspend 354 days. I'm going to give you credit for 9 days that you've already served. I'm going to suspend the entire fine amount. I'm going to order that the 2 sentences in each of those 2 counts run concurrent. So you'll serve both those sentences at the same time.
I do have a warrant out of Grace Harbor and somewhere else. I'm also have a warrant out of Tacoma, but I'm on personal recognizance, and I'm gonna get all that finished out here pretty soon.
Who gave this guy a PR bond? Like, seriously?
Within the month, hopefully, before the end of the month. So I don't know if they're gonna take me back. I don't know if I don't know. I'm not sure if that's gonna affect anything, but yeah.
He sounded so mentally sound right there. So I don't know. I'm sure there is an element of mental illness, but I don't know how much it plays a role, because he was very cognizant of what he was saying in that moment. But the moment that he's not speaking and there's no attention directly on him, he seeks it. And he acts like a 4-year-old. You know, the look at me, look at me, look at me, look what I'm doing, look what I'm doing, yell at me, because bad attention is better than no attention at all. I don't know how much of this is mental illness or how much of this is just parenting fail.
Mr. Landers.
I'm not sure. I don't know.
Okay.
Yeah. Thank you.
You're welcome, Mr. Landers. I'm just completing that judgment and sentence. Give me just 1 second.
Okay. Não me tira fato de justice. Privilege to exist. save one's life.
Okay, Mr. Landers, I have signed that order.
Just over yours.
Sure, you should likely be released later on today or tomorrow.
Okay.
And I wish you the very best of luck, okay?
Thank you, Your Honor. Thank you, everyone.
Thank you.
Jarrell Sewell. Can you unmute and state your name for the record? Okay.
Jarrell Sewell.
Okay, thank you. Now calling 22S00621 as well as 24FB1253. These are the state of Michigan versus Jarrell Sewell, who just stated his name for the record. Thank you. And today is the date and time set for arraignments in these matters. What I am seeing is that bench warrants issued for your arrest in each of these on February 28th of 2025. And that was for failure to appear. It looks like you were scheduled for a final settlement conference in the matter ending in 1253. And you were set for a show cause hearing in the matter ending in 0621. So, Attorney Moten.
Ashley Moten, Assistant Public Defender, appearing on behalf of Mr. Sewell, who has presented himself today. So we request a personal bond.
Okay, thank you. And I will note too, for the record, it looks as though Mr. Sewell, you have an attorney appointed, David Burgess.
Yes, I still haven't talked to this guy.
Okay. So I will note just so that you are aware then that we'll have the public defender represent you for the purposes of the arraignment today. But you have this attorney Burgess. I've got a phone number here for him. If you want me to put it in the chat, I can do that.
Yes, thank you.
Okay. And I should note too that if you got the notice of hearing for today, that his contact information is on that as well. All right. But you've got it in the chat now if you're able to screenshot it.
Thank you.
You're welcome. Okay. So at this time, then, let's see.
Oh, I do see that there is an active warrant for 1253. We request that the warrant is recalled.
Warrants on both matters, it looks like. So, Mr. Sewell, attendance appears to have been somewhat of a problem for you. If I set you for a pretrial in front of the judge.
I mean, I'm here. So, it's like I'm trying to get this stuff over with. It's just sometimes I got a lot going on with all this court stuff, with a lot of traffic and stuff. So it's kind of hard to keep track of everything, but I'll try my best. I'm here today to try to resolve this, to get this out the way.
Okay. And I do see, it looks like we have a phone number for you ending in 9756.
No.
Okay. So that is from January. I don't know if we've got a
Oh,
more
no,
recent
sorry,
one at
that
this
is it. Sorry, because I had switched
Okay.
my number. 9756, yeah.
Okay. So keep your information updated with the court. You're supposed to be doing that anyway, but particularly if you're getting text message reminders, we can only send you text message reminders if we have a good phone number for you. Okay.
Yeah.
What I will do.
So this
And
court
this is-
date I was actually at, but I was at work, man. So it, like how it happened was I was at work. I was trying to stay on it, and
Look,
it just went.
okay. So I can appreciate there's any number of reasons why a failure to appear happens. Okay.
Yeah.
I will recall the bench warrants this time. However, I am fairly confident that if you fail to appear for the next court date I set for you, the judge is going to have some words for me, and I will be much less likely to recall a bench warrant for you again. Okay? So, we will try this one more time. And you should reach out to that attorney. As I said, I put the phone number in the chat.
Yeah, I'm waiting on the date, man. I'm gonna set multiple like reminders, because
Please do. So, these are both. April 17th. That's going to be a pre-trial conference date. That will be at 9 in the morning over Zoom in front of the judge. So, April 17th, 9 a.m. in front of the judge over Zoom. You've got a good phone number. There's a tablet in the lobby at the township if you need to appear that way. If for some reason your phone isn't working at that point, all right?
yeah. I'm well, as you were speaking, I just said like multiple things. So yeah, only way I would probably forget if I lose my phone.
Okay. Well, if you lose your phone, you know you've got a court date coming up. You know it's the 14B district court. Call the court, call the public defender's office, walk to the 14B district court or the public defender's office, okay? You know you've got a date coming up. Do not miss this court date or any of the other ones. What was that?
You said the 14th?
It is April 17th.
Okay, yeah.
Okay. 9 in the morning. Okay?
It just sounded like you said the 14th. I'm like, okay.
Nope. I said 14B district court. So if you have to, you can walk to the 14B district court. Just show up for court. Okay?
Yeah, pretty much.
Thank you. So, Attorney Moten, do you have anything that you want to say?
Nope, we confirmed the phone number ending in 9756, right? Mr. Sewell?
Yes.
Okay, I'll give you a call this week.
Well, I will
Thank you.
point out as well, it seems that the public defender's office withdrew from his case and he has an attorney appointed. That's this Mr. Burgess. So I don't know if you can help facilitate that at all, but.
For some reason, we're still listed on the 621 case. So I'll figure that out before I call him.
Okay. Okay, then. Mr. Sewell. You've got your next court date. When is it?
The 17th of April.
Correct. At 9 in the morning. So.
I'll be there just because of you.
Oh, well, thank you. I appreciate that. So, you are free to sign out of Zoom, and we will see you on the 17th.
Thank you.
I really don't think flirting helps you, guy.
You are welcome.
This is case number 06-13291. This is Focus Hope versus Joyce Bivens. The matter is before the court on an objection to a writ of garnishment. The record should reflect that in this case, a judgment was entered in 2006, and that judgment due I should say the judgment was entered in 2007. It was renewed subsequent to that time. Judgment of entry was for $4,303.82. This is an effort to collect on that judgment. Your appearance for the plaintiff in this matter.
Good morning, Your Honor. Timothy Tremberth on behalf of the plaintiff, P79117.
All right, thank you, counsel. And I'm also looking for Ms. Bivens, if you're on this Zoom, say something at this time.
Yes, good morning, Your Honor.
All right, good morning to you, Ms. Bivens. And I do see that there are two objections to the writ of garnishment. One, in relation to the Michigan Department of Treasury. The other is in relationship to, it looks like Giant Janitoria. All right, in reviewing the objection to the writ of garnishment in regard to the Treasury, it says I object to the written statement I received from the creditor because the balance of the judgment is wrong. The other objection I received regarding Giant does not have anything specified. Tell me, ma'am, what's the basis of your objections at this time?
Your Honor, I love my son very dearly. My son was an adult when he entered into that school. It was a free program, as far as I know about Focus Hope. I don't know anything about me being charged for my son's attending school. When the attorney sent the letter to my part-time job, which is Giant, they referred the letter to me, and they had it in my name as if I went to school. I did not attend Focus Hope. My son Tyrone Bivens attended Focus Hope. And my treasury that I'm trying to get my federal funding is, I'm on a fixed income, I'm on SSI, and my adopted children was foster care kids. Those are their funds. I don't have much funds. And this is my son's bill. It's not mine. They did not even indicate my son's name on it when they sent it to my job, which is Giant.
All right, thank you, ma'am. Well, the issues that you're raising at this point are pre-judgment issues. Those are issues before the judgment was entered. There was a lawsuit filed against you back in 2006. You didn't answer the lawsuit, and that's how the judgment got entered. That judgment has been in place for a substantial period of time. So you can't really raise those objections today. That judgment is not only against Tyrone Bivens, that judgment is against Joyce Bivens. And that judgment, again, is from back in 2006. This judgment's been around for a long time.
Yes, it has. And I've been going to court about this, that this is my son's bill, and they have been taking his taxes when he was working. So I'm not clear on how it's got to do with me.
Yeah, well, the judgment is against you. It's against you. And when you understand that part of it, then I understand some of the arguments you're raising, but the issue is that you have a judgment against you. This is way beyond the school. You have a judgment, and that judgment is 14 years old now. Let me hear from the other side, counsel.
Your Honor, I would just say we rely primarily on our response, given that I think you hopefully received it. And as you stated, the defendant's objections are based on attacking the judgment, and an objection to garnishment is not the proper way to attack those, and it's not appropriate to attack that in an objection to garnishment.
Yeah, and that's a number one part of the challenge here, is that there is not a valid objection that's being raised at this time. To the extent that Ms. Bivens, that you feel that the judgment should be set aside, you have the right to file a motion to try and get that set aside. But as I pointed out to you, it's already been 14 years, but you can't attack it in a post-judgment hearing. The only kinds of things that you can attack in a post-judgment hearing like this is things like the judgment has already been paid. I've already set up a payment plan, things like that. None of those issues have been raised, and so there's not a valid objection. First of all, as it relates to the Michigan Department of Treasury, and there's certainly not a valid objection as it relates to Giant janitorial in this matter. Now, you pointed out that you receive benefits by way of the federal government. Certainly, those benefits cannot be garnished. In other words, if you receive any type of disability or anything like that, if someone tried to garnish your bank account or something like that, they can't do that because federal funds are exempt from garnishment. But certainly, if you're working, they can garnish your wages at work, even if it's part-time. And if you file a Michigan Department of Treasury tax return, they can garnish the tax return. They can't garnish anything federally. They can't garnish a federal tax return. They can't garnish federal disability payments. None of that is stuff that can be garnished. They can garnish the Department of Treasury tax return, and they can also garnish any place that you might be working. And that's the nature of these two guards. I don't find a valid objection. The issues that you raise, you can raise those in the context of a hearing where you're seeking to try and get the judgment set aside if you wanted to do that. And again, I already pointed out that this judgment is 14 years old. I know that you pointed out to me very clearly that it was your son that went to school. I don't know how they got a judgment against you, but apparently you signed off for him to go and there was cost involved. I don't know if that's true or not. I know that
I
you
never
have judgment.
did. No, I never did sign off on anything.
No, and don't care. Don't know and don't care. And I'm not being insensitive to you, but I need
I
you to hear
understand.
that you got a judgment. That's the part you need to hear, because it's that judgment that's causing you problems. That judgment can interfere with your wages anywhere you work. It can interfere with bank accounts. And again, like I said, if you got money in there that's from some type of federal benefit or something along those lines, they could hold the account up, but they can't garnish it once you establish that it comes from the government. Anything else, they pretty much can come after you because this judgment is against you. And I need you to understand that part. And you can decide what to do next, but as far as attacking the garnishment, you don't have a basis for that because there's a judgment. All right, that's my determination. You'll get 2 orders from me in the next couple of days. I do wish both sides are well regarding this regarding these matters. So, good day to you.
Thank you
All
very
right,
much.
thank you, Your Honor.
All right, this is case number 10-5669. This is Aaron Financial Services LLC versus David Williams. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect that a judgment was entered in this case on the 10th of August 2010. That judgment was renewed subsequent to that time. Looked like that renewal was 7/20/20. And the judgment balance at the time was $1,986.46. All right, your appearance for the plaintiff in this matter. For Aaron Financial. Do I have David Williams?
Yes, sir.
All right, thank you, Mr. Williams, and good morning to you. I know that you have filed with the court objections to a writ of garnishment. I also know, all right, counsel, are you here on Aaron Financial?
Yes, good morning, Your Honor. Brad Johnson, P75416, on behalf of the plaintiff.
Okay, all right. Somehow I called for you earlier and didn't get a response. So thank you, counsel. I see the objections to the writ of garnishment. I also see a motion to set aside a default judgment in this matter. All right, so let me first address the motion to set aside the default judgment. It says that 21 days have passed, but I've not been personally served, and I have good cause for setting aside the default in this matter. I'm looking at the file, and just one moment here. Contained in the court's file from 2010 is an affidavit of service by posting as allowed by the court at the address on Penrod to Mr. David Williams. Personal service was not required because the court allowed service by posting. All right, so the issue of personal service is not an issue in this case. Moreover, it's been 15 years, and this is the first instance of a motion to set aside a default. So what are you talking about, Mr. Williams?
This is my first time ever hearing about it. When I got the writ of garnishment by my employer, I never knew. I wasn't even in Michigan at the time when they were saying they was trying to serve me. I stay in Florida, sir.
Yeah, well, the judge at that time, many years ago, allowed the service by posting. So that that is good substance service.
But how can I, I'm sorry, sir, but how can I, dispute something that I didn't even never know about?
I don't know, but no, ma'am, you can't say anything at this point. Over several years, there were several notifications of garnishments against income tax involving your social security number over several years, back in 2010, 11, 12, so on and so forth.
You would think that over the course of 15 years and multiple taxes just disappearing, you'd think you'd know something was up and that you might owe somebody some money. And the fact that you get letters explaining where your income tax went to when it is garnished, you had a clue, dude. You had a clue.
And so you, 15 years later is when you come forward and say that you never heard anything about this. And of course, the information that you provided, even as it relates to your objection, that certainly does not have a Florida address. So I don't think I see a basis for setting the judgment aside. I'll address the other issues in a moment. Let me hear from Mr. Johnson on this, sir.
Yes, Your Honor, thank you. Based on the defendant's motion, he was under the impression that we had the Southfield address for 15 years, and that's just not true. It was served appropriately back in 2010, and we've renewed the judgment. We are way past any type of reasonable time to talk about setting aside a judgment that has been renewed.
Yeah, it's just, I just don't see a basis that would allow me, although, I'd look for that. I don't see a basis that would allow me to set this judgment aside. There's just no basis to set it aside at this point. So that motion in that regard will be denied at this time. Just, I have to have a legal reason, and I have no legal reason for setting this aside. So I can't set the judgment aside. Now we deal with the objection to the writ of garnishment. The objection to the writ of garnishment says, I never received notification until 15 years later. I never had a chance. My address that's not my address. I believe the information is fraudulent. You can't even raise that in the context of an objection to a writ of garnishment under the court rule. So you don't have a valid objection to the writ of garnishment. Legally or factually, do you have a basis for setting aside the garnishment? So let me ask you, sir. It looks like you work for OWI or CWI Logistics. Is that correct, sir?
That's correct, sir.
So has any money been taken from you regarding this case?
Yes.
All right. So how much? So do you get paid weekly, monthly, or twice a month?
I get paid weekly.
I'm
sorry, go ahead.
I'm trying to find out how much has been taken from you in terms of weekly under this garnishment.
It's $168 a month. A week coming out of my check.
All right.
And I'm not even getting 40 hours.
Got it. So that's hitting you for this one more 4, 5, 6, about $700 a month, right?
Yes, sir.
All right. This
And may I say
judgment.
something? Okay.
Yeah,
Yes.
just a moment. Yeah, this judgment started out as $1,800 back in 2010. Counsel, what are you showing as a balance on this judgment this time?
Your Honor, I'm showing a balance on the judgment today, $5,530.61.
Have you received any payments on the judgment, sir?
Yes, Your Honor, we received a check. Well, we received it March 11th in the amount of $125.60. And then, hold on. Then March 18th, we received an additional check in the amount of $145.52.
All right, so any other payments that you're noting over the years?
No, Your Honor, as the court can see from the record, there've been like 30 a lot of garnishments issued, unfortunately. And this does happen. This is the first one that actually hit where it was successful.
All right, sir. So I know I'm on the record here. Have the parties talked at all in a breakout room to see if you could reach some kind of way of resolving this? Because what happens is that the judgment been in place 15 years, you got interest accruing on that. And it started out at like $1,800 or $1,900. The defendant is saying one of the issues here is that he did not receive notice legally. And there's a difference between legal notice and actual notice. Legally, I find that there's notice, but he's saying that he didn't receive notice. So it probably, here are two things I'll say for you. It's probably worth talking to see if you can come up with a number that resolves the case, something less than where it is now. The other thing, just listen to me. You can do whatever you want to do. I want everybody to understand that except for when it comes to the law and what I have to do, I'm gonna do what I have to do. You can do whatever you want to do. I'm gonna do what my responsibility is to execute the law. Sometimes I can give people some direction as to how you might be able to resolve it. You don't have to listen to me when it comes to that. I issue orders, but I know right now that what you're dealing with is a garnishment that's going to hit you for $700 a month. I can tell you that I will likely grant something less than that amount so that you're not able to garnishment that high. But maybe you can find a way that both parties talking to see if you can get away from that $5,500 that this has blown to. Okay, that's the only reason I'm talking about it.
Can you imagine owing a little over $1,800 and ignoring it for what, 14 years or something like that? And now you owe $5,500? That's exactly what happened to this guy. Pay your stuff. Plus, over that time period, they were garnishing his tax returns. So they got some money. And it's still $5,500. I can't even imagine that. Just pay your debts. Like, seriously. Don't let this happen.
Listen to me now.
I'm sorry.
That's the only reason I'm talking about this now, to try to see if there's a way to help you going forward with this. That's all I'm trying to do. You may disagree with my rulings on the other stuff. You can always appeal me. You can always file something else. But hear me on this part of it. Okay, this part of it is if nothing changes here today, that garnishment is going to stay in place, and you're going to get hit for $700 a month. I will reduce it.
Can I speak for a second?
Do you understand everything I'm telling you?
Yes, sir, I do.
You speak and you tell me something that's crazy, then I'm gonna be stuck with what you're telling. Go ahead, I'm listening.
No, sir, I'm not gonna tell you anything crazy. Right now, like I said, I'm not even getting 40 hours a week. I'm the primary breadwinner in my house right now because my wife is battling cancer. And that is gonna really, really put me in a bad situation. I have a child. I'm not telling you anything crazy. I understand that, what your judgment is, but I was just asking is there any way possible that could be, reduced or something, because that's going to really put me in a bind.
Absolutely.
Especially after 15 years when I could have been paid this. He's talking about there's been failed garnishments, but this could have been resolved. I didn't know anything about it. This is my first time ever even knowing about it.
He wasn't even in Florida. That's not your address.
And the other address that he has, that what they said that was the whatever was sent to, I've never stayed at that address in my life. I've never even known about the address.
You've been in Florida since 2009.
So if you want me to, I'll go hear other cases and come back, because you're telling me the same things that you already told me before. And that's okay. If you want to talk about that, that's okay. See, I told you, and the first thing that you started out saying, it makes sense to me. I'm not going to leave you under that $700 and something a month garnishment because you told me earlier that you're working part-time. Then you added information that you're the sole breadwinner, that your wife has suffered with physical ailment, so on. So I take all that into consideration, okay? Two things that are relevant here. Now, I could just leave that in place, but I don't want to do that because I know that this has been going on for a long time, so on and so forth. The other thing that I know is that most of the judgment now is interest. So that's why I said talk aside. Maybe you can come up with some agreement where you get some of that interest knocked off of there. We have a lower amount. That might be worth talking about. Okay, I can address today just the garnishment. You talk to the other side, maybe both of you could talk about what to do about some of that interest that has improved. Like I said, this started out as about a $2,000 judgment. It's $5,500. You had $3,500 in interest. So you may want to try to address that part. Then the final thing that I'll point out to you is that you can still file motions to try to get the judgment set aside from 15 years ago. The problem is it's 15 years ago. The problem is the thing that I described to you about what the files show. The files show legal service. The files show a alternate service that was allowed by a judge, not by me, but many, many years ago. And that established the way that this case would go forward. And that kind of ties my hands, okay? So that's the reason that you have the rulings that I made on the other issues. Now, I don't particularly like it, but that's the way that is. Now, the challenge is going forward. So my sense about this is based upon what you have communicated to me, that I would cap your payments at $200 a month, so it'd be $50 a week, and that would cap the payment. But what you want to try to do is figure out a way if you can reduce the overall balance based upon how long this has been. And so instead of taking $700 a month, it would be taking $200. You'd be going towards paying it. If you could discuss trying to get some of that interest taken off, then that's going to lead to you getting it paid off back. That's what I'm getting at. And again, if you see a way to try to get the judgment set aside, if I knew a way, but I really couldn't tell you because I can't give you legal advice. But if you find a way to get it set aside, I can't think of a way. But if you find a way, then I'll still be willing to hear that. But I just today, based on everything I've seen, there's nothing I can do about that part. Okay. So let me do it this way. I've already told you that I'll reduce that payment to $200 a month, $50 a week. Let me let you talk with the other side and see if you can do anything about the interest on this. And if you do something about the interest, maybe you can figure out a more aggressive payment plan and that'll reduce the amount. I don't know, but talk with him for a moment and then come back in. I'm going to sign the order reducing your garnishment amount. But again, if you can get the others reduced, then that'll put you that much further ahead. You understand?
Yes, sir. I understand. Okay,
so let's try to do that part. And I'm sending you in with Mr. Johnson, and then come back in. Let's see if we can work on it further. Because again, I know it's been 15 years, and I know that most of that is interest. All right. All right. So click on into the breakout room, and then we'll talk on the other side.
Yes, sir.
Let me step back for a moment to Arrow Financial versus David Williams. The suffix in that matter is 5696. Welcome back, Mr. Johnson. Welcome back, Mr. Williams. Mr. Johnson, updating on things, sir.
Thank you, Your Honor. Mr. Williams and his wife graciously were in the breakout room. They gave me a proposal regarding the interest. I don't have approval for that at this time. They did give me an email address where I can communicate with them further. But yeah, we really have nothing on reducing the balance at this point.
All right. So I'm going to sign the order to allow for the garnishment to be reduced to up to $50 up to $50 per pay. And that will reduce that amount. And sir, Mr. Johnson, they're going to hear back from you when regarding this matter?
I'm putting in their proposal to my client today, and as soon as I hear from my client regarding that, I will reach out to this email address and let them know, and then they can do the next steps, whatever those are. Hopefully they accept their proposal and we can just move on with this.
All right. So what I'll do is I will set a review date just so I can take another look at that issue, and I'm going to go ahead and set that up for April the 17th, 4/17/25 at 9:45. That's when it will come back in front of me. Let me take a look at it. Hopefully you guys get it worked out, and I'll take a look at it at that time. And in the meantime, Mr. Williams, you'll get an order from me limiting the amount of the garnishment to $50 per pay. And we'll send that to your payroll department. But when you get it, you make sure that you take it to them so that they can reduce it to the up to $50 per pay rather than the amount that is being taken there.
Yes, sir. How would I receive that?
I'm going to send it to you in mail at the address in Southville on Lindenwood Street.
I stay in Florida.
We sent in a correction of address.
I sent in a correction of address.
Yeah, the only address I have is the Southville address, and then I do have the address to the Auburndale, Florida address regarding
Auburndale.
That's your job's address.
Sir?
Yeah, I have your job address. Let me see, just one moment. Just a second. 1 second. Okay, I do have something on, I believe it's 6 Lake Ida Street.
No, sir.
No, sir.
890 Winter Haven.
Excuse me?
I'm trying to figure out, well, wait a minute, I see a bunch of stuff. Okay, what about 35th Street?
Yes, sir.
That's
Okay,
correct.
that's in Winter Haven, correct?
Correct. Yes, sir.
Okay, I'll make sure that it gets sent to that address, sir.
Yes, sir.
All right, and then you have, you're gonna get something with the next date on this, just to try to deal with the interest of it. There's not a whole lot I can do, but I wanna hear where the parties are and see if there's anything further that can be done. So I'll review it on the 17th of April.
Thank you, sir.
So receive an order from me in the next couple of days. All right, good day to you. Thank you, Council.
Thank you, sir.
Thank you, Your Honor. Thank you, Mr. Williams, Mr. and Mrs. Williams.
Thank
Yes, sir.
you.
Thank you, sir.
Good day to both. Okay, this is case number 12-105-299. This is Asset Acceptance LLC versus Mariah Corley. The matter is before the court on the filing of objections to a writ of garnishment. This is regarding a judgment that was entered in this case in 2012. The judgment was renewed in 2022. And in 2022, it was indicated that the amount owed was $3,690.09. The judgment previously was $6,390. Your appearance for the plaintiff in this matter.
Good morning, Your Honor. David R. Monroe, P18081, Appearance Counsel for Asset Acceptance.
Thank you, Counsel. Good morning to you, sir. I'm looking for Mariah Corley
I'm
on
here.
this. All right, thank you, Ms. Corley, and good morning to you, ma'am. I did look at your objections to the writ of garnishment. You said I'm not who they are trying to say I am. I wasn't old enough. So tell me what you're talking about there. It looks like this was somebody's paid on this judgment before. What's going on? What are you telling me, man?
From my understanding, I have received a letter in the mail about, them garnishing my taxes. So, when I had contact, the parties about the matter, they told me that a bank account was opened in 2006, March 20 2006, and I told them that I was 14 at the time. And the name that they had sent the letter in, I was adopted when I was a kid. So my birth name was Jessica Wright. And my name now is Mariah Corley. So I had to take my foster parents' last name. But the name that they're talking about, that's no longer my name. And I was 14 at the time when the account got opened.
That means that most likely her biological parents fraudulently used her identity after she was sent off to foster care or whatever the case may be. That is trash, y'all. That is absolutely vile. That is trash. I don't care who you are. If you're going to steal your child's identity and ruin their credit for their adulthood, you're trash.
So I don't know anything about it.
All right, so counsel, I am seeing the judgment entered as Jessica Wright. And then I see it, a subsequent indication of a formerly known as that then includes the name of Mariah Corley. And Ms. Corley says, of course, that she was a minor at the time that any of this occurred. Counsel, go ahead and talk to me.
I'm told by asset acceptance, Your Honor, that they have accepted her claim, her proof of fraud, and they are in the process of moving to vacate the matter in the case of the current garnished defendant. I would suggest you give us a month or so to get all that done, and hopefully it'll go away.
Your Honor, can I say something?
Sure.
They said give them a month or so, but the people that I had contact, they told me they was gonna send me something in the mail, and that was over a month ago. So that's why I decided to come down to the court to get a court date. They haven't sent me anything in the mail for me to even send to the IRS. I have 2 kids and I'm a single mom. And the fact of them taking my income tax, I do not appreciate it. And they haven't did anything that they said they were going to do. Give you a month or so when I gave you over a month already. Like, it's not helping me out. I have bills, I have kids, it's not helping me out. Keep waiting. When I told y'all that wasn't me from Jump Street.
Finished?
Yes.
Okay, so you agree with them that this should be set aside, right?
Yeah.
Okay, that's what I thought. I know I'm glad you got that off your chest.
I just want my money.
I'm glad you got that off your chest. Want your money, there's a process involved. I'm glad you got that off your chest. All right, I agree that based upon what has been indicated here, that the objection is a valid objection. There is some paperwork that they got to do, but as far as before the court, counsel as an officer of the court has indicated that based upon the due diligence of asset acceptance, they've determined that your objection is a valid objection. Therefore, the court will find that the objection is in fact valid. When you told me that you were underage, that becomes a huge issue here. And if they hadn't looked into that I was going to have you present information, because if you could prove that you were a minor at the time, that would resolve it by itself. But they've already said that they agree with you that there was some fraud involved here. So I find that the objection is valid. Any funds withheld will be released to the defendant, that is to Ms. Mariah Corley. All right. I wish you well, ma'am. Thank you, counsel. And whatever process the agency goes through, they can still do that. But as far as the objection, I have to find that the objection is valid at this time. So, okay.
Your Honor, I assume you will file a written order to that effect and send it to them?
Yes, I'm signing the order now. A copy of this order will go to Ms. Corley. It will also go to the Michigan Department of Treasury.
Thank you so much, Judge.
All right, thank you, Ms. Corley. I'm glad you got it off your chest. Go take care of it.
Good day, Your Honor. Thank you, sir.
Good day to you. On the record in 5754, Automotive Credit Corporation versus Pleasure. Are you on that matter, sir? Your appearance, if you will, on automotive?
Oh, I'm Attorney Richard Rusin. I am the attorney of record for the plaintiff, my bar number 35222. Today, Judge, I am the respondent to defendant's defendant's objection to a bank garnishment.
All right, thank you, counsel. And I have Mr. Pledger on this Zoom at this time. Mr. Pledger, I looked at your objection. It says you never received any notice of a letter and money was taken out of your account. Of course, I mentioned to you that the reason for the garnishment is that outstanding judgment. Tell me what you're trying to tell me, Mr. Pledger.
Well, I mean, I know that I do owe for the car or whatever, but usually, like when you get garnished, they give you you get notified in the mail that they about to garnish you. And
No, not on the garnishment. You get the notice after the garnishment. That's the way. That's the whole point of it, to keep you from going and getting the money. So it's supposed to come by surprise.
yeah, but
Go ahead. Go ahead.
one thing on that with that account, it was me and my girlfriend's joint account, but they told me that my car was closed, my account was closed. That was her income tax money that came to the account, and they just up and took it. That's what the whole issue about. I'm not knocking me on them or whatever, but it's just when they did that, that was her income tax money that went to that account. Like, I don't even use that account or nothing. They told me my end was closed. I didn't even know my name was still on the savings part. And that's where they got it from.
Yeah, that makes you an owner of that account, unfortunately. Well, let me hear from Mr. Rose and I'll come back. How much money was taken, Mr. Pleasure? Do you know?
Like 1,700.
Right. Mr. Rose?
Well, Judge, may I please the disclosure from the bank. Apparently, the disclosure from the bank was for the sum of $1,611. Now, I can tell you, Judge, I have no information about any co-owners in the bank account. I have no information but for the two documents I've received that brought us to your docket today, which is Mr. Pledger's objection, and the one-page document from the bank said we're withholding $1,611.
Wow. But, Mr. Pleasure, if that being the case, I mean, it's got your name on it, and that's money.
Yeah, not that being said, that's the problem I have, Judge. So I don't have any way to dispute or
Mr. Rosen, you're breaking up completely. I need to hear what you're saying now. Maybe you should can you go out and come back in, because you're breaking up bad.
Go out and come back. Yeah.
Okay.
I'm going now. I'll be right back.
Okay. Just one moment, Mr. Pledger. I want to hear what he had to say.
There we go. Let's try this again. All right. Judge, can you hear me?
Yes, sir.
Okay, great. So the only information I have in listening to Mr. Pelger's argument on the record is just his one-page objection and the one-page disclosure I received from the bank. And again, if this, based on the record, if it's a joint account, he's got equal access as to the account money as well as his girlfriend. So therefore, I ask you to deny the objection today. My name's still on there.
Yeah, Mr. Pledger, given that you're joint on this account, that your name is still on it, there's nothing here to establish any other ownership on the account. when your name is attached to something, you have a judgment, that makes those items subject to garnishment. And therein lies the problem here. You know, go ahead, I'm listening to you, Mr. Pleasure.
You said, and there's no other, they said there's no other name on the account?
Well, the notification, I believe the attorney said that he received it, did not display some other person's name, but it definitely has your name. That's the problem. That's the biggest part of the problem, is that your name and your identification is attached to that, and then you have a judgment. So that's why the bank seized the money, because that judgment says if you have some money with Mr. Pleasure's name on it, then you got to turn it over, and that's what they did. And I don't see an objection to that. So, you know, looks like you're gonna have to pay your girlfriend back if that's her money, because your name is all over. All right, so I would have to find that there's not a valid objection here, Mr. Clegg. And the funds would then be released to the plaintiff to be applied towards the judgment balance. I do wish you well, sir. Thank you. Good day.
Thank you, Russ.
He kept looking over to the side when the judge was making his ruling, and you could hear her at one point right before the time transition, but you know darn well he's going, I'm sorry, I'm sorry, I'm sorry. Well, I mean, you know, it could just be a normal girlfriend and they're cohabitating, and so they got a joint bank account. I mean, it doesn't have to make her crazy. It's not something I would do. I mean, I'm sorry. I would not put my dating partner's name on my bank account unless there was, you know, a very, you know, important ring involved. That's the only way they're getting on my account. And even then, I'd probably still have my own account. I don't know yet. I've been married and divorced once. You know, that was enough. I don't want to deal with all that again. I like the separate accounts idea. Well, hi, Tiny Kitten Esquire. You've been so vocal all night. Everybody's heard you. Everybody's heard you talking. Coming in for a snack. Oh gosh, you guys. Oh, I thought that said crazy. Oh, I'm tired. Yeah, I'm tired. Okay. Yeah. I'm not even reading the real words now. I'm making stuff up in my head. Eileen Carlin says, meow. She would reply, but, you know, she's got her face full. Oh my gosh, you guys, thank you so much for coming and hanging out with me and watching my crazy cats climb all over me tonight. I don't know what was in them. Oh my gosh. Earl was something else. Right there, that is a diffuser called Feel Away, and it's supposed to give off cat pheromones, and it's supposed to calm them down, make them less aggressive, you know, ease their stress. I think Billy really likes it because Billy used to sleep right here on the end of the bed, but he's been sleeping right under the diffuser lately. And then those drops that I got right there. Oh, hey, you know what? I've got a couple here. The Jackson Galaxy Bully Solution. I really think that's been helping. I've been using I've been using the self-esteem drops on Bandit and sometimes on Tiny Kitten. And I've been using the bully solution on the boys. I bet you can't guess why. I think everything's going to be a lot better after Tiny Kitten Esquire gets fixed, though. She goes in 2 weeks and then gets spayed. And then the boys probably won't have as many dominance issues with her. Oh, there's Jackson Galaxy. He's a world-renowned cat behavioralist, but these products that he has, they do work with dogs as well. They're for cats and dogs. He's got a lot of stuff available. You should really look into it. Of course, he's amazing. I've learned so much from him. All right, guys, I am going to go and I'm going to get some sleep. Well, actually, I'll probably work on getting some Replay Crew minis. I didn't get any up today. Yesterday, we got 5 inches of snow. And then the only 2-hour delayed school. It was crazy. And there was like this much ice and then the snow on top of that. So that made it even worse. Yep, the cat daddy. Yeah, I love him. I actually thought about contacting him about Bandit and Earl, but I ended up on his website. Oh, I got their favorite toy ever from his site, and I love it. It's called the Gotcha, and I'm telling you, this is the best toy ever. Look at that. Right after it. And it has not been sprayed with anything. Like I did not spray catnip on it or anything. But so it's got the telescopic wand, so I can choose how far away from me I want it. And then this is also, you can choose how long you want it. And you just push the little Jackson Galaxy cat logo right there, and it retracts it right back up. So I can play with them here at the desk, or I can extend it and play with them on the bed just as easily. And they love this toy. Seriously, this is just amazing for them, especially Earl. He just goes crazy over it. And he's the one that needed it the most. Well, Billy needs the exercise, but Billy he'll chase it on the floor level. He likes getting it when it's like creeping across the floor. Earl likes getting it when it's in the air. But I love it. Love it. Yes. Oh, look, there's Billy. Billy's like, oh yes, it's playtime. Look at him. He's stalking it. Oh, Tiny Kitten for the win. Yeah, all of them get going. Other than Bandit, she won't come out for it yet. She's starting to get a little more playful, but I have not gotten her out of her shell yet. It'll just take some time. Man, Tiny Kitten is a regular little predator. Ha! This is so great. Yeah, it's called the Gotcha. I think they have them for like $23, I think, if I remember correctly. They have so many good things on that site, though, that I wanted to get the kitties. Hey, come on, let me have it. Let me have it. Even the ones that I have that are very similar to this, they don't like nearly as much. This is their favorite, hands down. Hey, come on, come on. Come on, he's mine. He's mine now. Oh, he's got it. He's got it good. Only if necessary. I haven't had a need to yet. Yeah, but those are more for the dog, the plush toys. But Ava's not really big on toys of any kind, so. Yeah, cat toys pretty much consist of feathers, anything lightweight that they can catch, and they like little springy things. They like little mice that they can bat around, anything that they can pretend is. I mean, they're natural predators, they're natural hunters. So that's what they absolutely need in their life. It has to resemble something that they can hunt. And then that's their play. And that's what keeps them happy. With the cats, I've put harnesses on Billy before and tried taking him out for walks because he likes being outside. And he slips out of them. He doesn't like being on a leash, but he does love roaming the yard. So it's kind of hard. It's kind of a hard balance because I don't want him to be out roaming and, go in the road because he does. But my dream is someday I'll have a property that I can put a fence around, and at the top of the fence, you have a 45-degree angle. It'd be an open yard and chain link fence all around it, I'm thinking like a six footer or an 8 footer, and then a 45-degree angle for about 4 feet. 3 or 4 feet. Cats can't, they're not supposed to be able to climb the 45-degree angle upside down. So it makes it so that you can have an open backyard where birds and squirrels can get in and stuff like that. And birds and squirrels can still get out, but the cats can't and the dog can't. So that's my goal in life. I will someday own a property with that backyard. All right, guys, we're going to put it away for now. No, you're not declawing them. You're deknuckling them. In order to remove the claws, they have to remove the entire first part of the finger. It would be like cutting all of your fingers off to the first joint. So, like, literally that would be missing on every finger that you have. No, that is cruel, and it can actually make a cat more aggressive. Yep. Yeah, their claws are their first line of defense. That is their warning. That is their security. You take that away, and what they're left with is teeth. And I would never. And so you can actually make them more aggressive. You've taken away all the power that they think they have. All right, guys. I hope you all have a wonderful night. Thank you for coming out and spending time with me. And hopefully we'll get to do this again tomorrow. Be safe, be well, sleep sweet, and much love.